Hi, it's Jen Rubin, editor-in-chief of The Contrarian. I am very happy to welcome Mark Zaid. For those of you who don't know him, he is one of the top lawyers in Washington, D.C. He is well known for his representation of whistleblowers, of people who have had their security clearances stripped, and he now has a especially bird's eye seat on that one, and many other types of litigation. He has filed multiple pieces of litigation against the Trump administration. Mark, welcome.
Thank you, Jen. It's a pleasure.
Tell us about your suit on behalf of FEMA's CFO.
Sure. So Mary Comans, who's been a federal employee for over 20 years and was the longest serving chief financial officer for FEMA in a nonpartisan, apolitical, non-political appointee, civil servant, senior executive service, as we call it, SES. She was unceremoniously, or maybe even ceremoniously, I suppose, fired on February 11th because, point blank, Donald Trump and Elon Musk mistakenly thought that FEMA's payment to New York State to reimburse it for housing migrants in New York City was made without permission, when it was actually authorized by DOJ and senior leadership within DHS. They were upset about it because someone tweeted it out, and they fired her with zero due process, none, nilch, nil, however one wants to characterize that. So we sued.
And what are the grounds for the suit? What are your individual claims?
So there are two actions that actually exist, and this is the nuances of getting into the weeds of, unfortunately, federal employment law. The lawsuit that was filed before the U.S. District Court for the District of Columbia is one under the Privacy Act, and that is because the DHS issued a press release that notified the world that Mary had been fired, that she was a deep state activist, and that she had circumvented her leadership. All of this is totally false. And by notifying the public without what's called a routine use exception, they took information from her Protected Privacy Act system of records and violated it. That's the nuances. This is a very crotchety old statute from back in the 70s that is generally problematic, but is a good weapon in this particular case, so to speak. The other action is before the Merit System Protections Board, the MSPB. And that is an administrative board that handles federal employment claims, especially when someone is terminated, usually because you're challenging the basis of the termination. In this case, while we are doing that, we're challenging that there was no due process provided to Mary, which is in violation of multiple statutes. And we are required, unfortunately, to go to the MSPB first to exhaust internal remedies or administrative remedies before we go to federal court. The irony of that is the Trump administration doesn't believe Mary or any federal employee has any remedies whatsoever, any rights, that they could just fire individuals per their constitutional authority. But we have to still follow the procedure and exhaust administrative remedies.
So what has happened so far in the lawsuit?
So those are both brand new. I mean, we're literally, as we're taping this, less than a week in. So all we've had to do so far is serve the government with the papers, which we've done, and we're just waiting on that process to start. We're not seeking what's called a temporary restraining order, not because what happened in the last 24 hours, which was the White House saying they were going to seek security payments from those who do seek TROs or PIs, preliminary or permanent injunctions, but because it's not available, frankly, to us. It's been too long. She's fired a month ago. We may seek an injunction. We shall see. But the bottom line, without getting into too much of a wonkishness of the law, we'll probably do what's called a motion for summary judgment that says there are no facts in dispute. It is a legal matter. She was not afforded due process protections, so the government loses on those grounds. And we'll ask the MSPB to reinstate her and order due process if that's what they want to do.
Now, there are a great number of employees, obviously, who this administration has attempted to fire. Probationary employees, for example, people who have certain protections because they are part of an independent agency. And again, we hear this claim that I suppose it stems from the unitary executive, that they don't have to pay attention to any of this. They don't have to pay attention to due process, to past precedent, to all of these procedures that have been in place in some cases for decades. How, in general, are the courts responding to this kind of conduct in the wide variety of lawsuits that we've seen so far?
So it's amazing how few lawsuits there have been so far about this. I expected it to have been more. I didn't expect us to be one of the first ones. The other similar cases have been for even more senior people, I would say positions that were appointed in past administrations to serve as, for example, the special counsel in the Office of Special Counsel, to serve as judges on the board for the Merit System Protection Board or the National Labor Relations Board, and I think even the Federal Elections Committee, although I don't think they've sued yet. But there's a number of senior administrative judge type positions that have their own statutes, the inspector generals that were fired across different agencies. They're very similar. The reasoning was similar. The president invoked Article 2 of the Constitution to say, as you mentioned, this unitarian thought process that the president has all the power, notwithstanding that Congress has created laws, which obviously past presidents signed into law, maybe over veto, but I think they all signed them, like the Civil Service Reform Act that governs in part our case, that sets forth procedures that there has to be a reason, a substantive reason for the termination. There has to be due process. What does that mean? Something written in paper setting forth what the allegations are, an opportunity to respond in writing and in person, an opportunity to have legal counsel, enough time to respond, etc. And they're disregarding all of that. So far, the courts have been generally favorable in reinstating people. The special counsel, unfortunately, just dropped his claims after the D.C. Circuit, our second level appellate court, basically said that while it's pending, he could be removed, and he decided to stop that legal action. Other than that, for the most part, everyone has prevailed and been reinstated, and the government, the executive branch, has been told you need to comply with the law. But the reality is, and what we expect, is that the president wants, and his administration wants, this battle, this fight, this war to go to the Supreme Court. And he will, as he did in the special counsel case, when the special counsel actually prevailed. It was on a Saturday night, and within 30 minutes, the government had already, like at 11 o'clock at night or something like that, had already appealed the decision. So they are taking this up to the Supreme Court to force the issue of where does the power lie? It is essentially a king or, a Democratic Republic administration that's governed by multiple branches.
Exactly. And without going into great detail, it has been the law, though it's gotten somewhat complicated over the years, that there can be certain independent agencies, certain types of jobs that have restrictions on them that the president can not simply summarily terminate. So should the Supreme Court go down the road that the Trump administration wants them to take, this would be yet another enormous expansion, distortion really, of executive power, and really leave the other two branches almost powerless if the president's actions can't be contradicted, if Congress doesn't have the right to control who spends the money. So we will look for that. I want to ask you about a couple other matters that you have. One is a suit you brought on behalf of FBI agents who were going to be singled out and perhaps their names revealed because they had worked on some aspect of the litigation involving the January 6th conspirators. My partner here, Norm Eisen, is also involved in that matter. Where does that stand right now?
Right. So Norm's organization and my law firm, we brought this case along with lawyers for the FBI Agents Association. So we represent, it's not even just agents, it's any employee who worked on January 6 cases. There were forensic examiners, technical examiners, computer examiners, fingerprint examiners, right? Analysts, etc. So we filed that case the first week of February, and we did seek a temporary restraining order because it was our understanding that there was going to be a mass firing of thousands of people who worked on January 6 cases from within the FBI, and that their names would be highlighted as, here are the enemies of the deep state type situation, which would subject them to doxing, harassment, threats. We saw former or past J6 defendants charged after and for threatening to kill the FBI personnel who worked on their cases and had sent them to jail the first time around. So we negotiated a resolution with the government for essentially, effectively, a temporary restraining order, but it's a consent agreement so that the government would not release the names of the individuals that ended up on this survey that they compiled to see who worked on the cases, and that was pending a preliminary injunction, which is now still being briefed. So we are still currently scheduled to have oral arguments on March 27th before the district judge to determine whether or not we would be entitled to a preliminary or a permanent injunction to block the disclosure of the names.
And as of yet, I certainly don't want to jinx things. There has not been this mass firing of those people. There have been individuals who have been fired. People have quit in some instances, but thousands and thousands of people have not been terminated. Perhaps even they realize that this would be extremely dangerous, extremely detrimental to national security, to enforcement of criminal laws, and the rest. I also want to ask about a FOIA request. That's a request that the government turn over information that is within their possession about the documents that Trump took to Mar-a-Lago. Tell us about that one.
Right. So, I'm sure most of your listeners know of the Mar-a-Lago prosecution for Donald Trump being prosecuted, as well as two of his staff, for maintaining possession of national defense information, what we know mostly as classified information, under the Espionage Act. This was the case down in Florida before Judge Cannon that failed because it got held up in procedural nightmares. But it is probably, in fact, in my view, this was the strongest of the cases against Donald Trump. I've handled many Espionage Act investigations and prosecutions over the years as a defense counsel in those situations or for witnesses. And I have no doubt that had it gone to trial, Donald Trump would have been convicted. In fact, most of those cases, the person pleads guilty because the evidence is so overwhelming, there's no defense to be able to justify what he did. Obviously, he fought it. He won election. And again, he's back in office. He can frankly do whatever he wants with these documents. And he did. They loaded them back up on a plane, and apparently they took them back down to Mar-a-Lago. So as soon as we saw that, that meant they had to have been declassified. He, of course, said that's what he did the first time around, even though there wasn't any real evidence of it. And as far as I know, there's not what we call a SCIF, a sensitive compartmented information facility. It's a mouthful. Essentially a room that's secure, not the bathroom, not the ballroom, right, where he had the documents before. So, hey, if they're declassified, that means we want them. So we filed a FOIA request and filed a lawsuit now on behalf of the James Madison Project and Brian Karam, who's a White House reporter, for the contents of all of these documents. They've either been summarized in various documents that the public has not seen as far as the contents, or the documents themselves. And the initial filing of the lawsuit is actually first to push for expedited processing because the Justice Department responded to our request to expedite the matter by saying, essentially, nah, there's no public interest here. There's nothing you guys need. And we went, okay, if you say so.
So you have not gotten a response on the merits, so to speak. In other words, they
Right.
haven't said, oh no, these are classified documents, nor have they given any other legitimate excuse for withholding this from the public.
Right. At this point, all they've said is it's not in the public's interest, or we can't show public interest to know what the contents of these documents are. Again, we have to abide by the rules. So we have administrative remedies we need to exhaust, which means we have to give the government 20 working days, business days, or essentially a month, a calendar month, before we can substantively sue for the documents, for the contents. But because expedited processing was denied, that gives us a procedural vehicle to go into court now, as we did, and then we'll amend the complaint to go after the actual contents of the documents as well.
The last issue that I want to ask you about is both personal to you and a growing problem in the legal community, and that is targeting lawyers this administration doesn't like, or doesn't like their clients, and attempting to interfere with their ability to do lawyering, with their ability to do business with the government. Your security clearance was stripped. There was no evidence that you had done anything wrong or made any violations. And two law firms now have been singled out, primarily because, frankly, it doesn't like the positions they have taken in certain matters. There's no indication that either one of them has done anything wrong. And in the most recent case, which involves the Perkins and Cole matter, they've even been barred from entering federal buildings, which would include federal courts, administrative proceedings. How is this possibly legal? And what is the danger to the profession at large and to the First Amendment?
Yeah, I'm really insulted by this one, because both Covington and Burling and Perkins Coie had executive orders stripping them of their security clearances, and all I got was the New York Post reporting that President Trump told them he took my clearance away. So I don't quite understand that, but you know, you got to have some humor about the ridiculousness of what's going on. It's a really serious threat. I mean, my work, I'm essentially an employment lawyer, but I'm one for spies. And who are those spies? They are American spies. They are individuals who work at the CIA, the NSA, the FBI, and elsewhere. And I'm representing them as in their employment cases, as whistleblowers during investigations, where classified information is required to be known. And I've had authorized access for classified information for almost 30 years. I've held a security clearance for almost 25 years. There's a nuanced difference between the two. But they're the same trustworthiness determination. And the basis for the stripping of mine was because I represented the whistleblower and the intelligence community during the first Trump impeachment. Ironically, a year later, in 2020, the Trump administration raised my security clearance level to what we call top secret SCI, TSSCI, for another whistleblower case that I was handling at DHS. So to strip mine as being that somehow I'm untrustworthy, I didn't even have classified information access in the first intelligence community whistleblower case. He just doesn't like that I represented the whistleblower. It won't impact me significantly. I mean, it sucks, and I would like my clearance back, and it really hurts federal employees in his administration, including his political appointees, who I usually end up representing. The situation with the law firms is really, really different. For one, it's an attack on lawyers who were just doing their job, right? We talked about Mar-a-Lago. Donald Trump's lawyers had security clearances. They had access to classified information as part of that litigation afforded them by the Biden administration. Todd Blanche, who will be our Deputy Attorney General in the United States, was one of those lawyers, right? You didn't see the Biden administration say, oh, no, we don't think you should have lawyers, Donald Trump. We're not going to give them a security clearance, because that's not how it works. And the Perkins Coie one is really different than any of the others, because it targeted not only a law firm for lawyers who don't even work there any longer, actually, but it targeted their clients. And it said, if you the client do work with Perkins Coie, be who we, the Trump administration, don't like, we will block you also. And these are going to be defense contractors and other companies who are doing business for and with the U.S. government, upholding governmental programs. I mean, it's incredibly vindictive, petty, retaliatory, non-American, and most likely illegal, especially the notion of what you mentioned about blocking them from going to federal buildings. I mean, I would love to bring that lawsuit. They insinuated that existed with me. I haven't seen it manifest itself yet, but you gotta love to see that they're going to be blocked from federal courts. Yeah, I really doubt a federal judge is going to abide by that. But look, this is at its core nothing but retaliatory vindictiveness against lawyers who he did not like. It has
Right.
nothing to do with their trustworthiness, their good judgment, or anything of the sort. And I mean, I can't denounce it enough. Everyone does. We work through Republican and Democratic Democrat administrations. Especially for folks like me, I could care less who's in the White House. I'm just continuing to do what I do in every administration.
Now, one could say, well, they should turn around and sue the government. But of course, that's what's so pernicious about this, because it is the attempt to ruin these law firms, because clients may think once, twice, three times about being represented by the firm or doing business with the firm in any way, because they don't want to suffer the retaliatory effects from the Trump administration. So they're damned if they do, they're damned if they don't. If they raise their profile and they litigate, that many more clients may defect. If they do nothing, this will set a terrible precedent. What do you think the legal community as a whole should be doing in response to this?
Well, I'm certainly hearing a lot of murmurs behind the scenes, a lot of lawyers contacting me saying they would, happily represent me, folks who were general counsels at federal agencies in the past. There have been some articles saying, and I've been in a number of them, about the absence of some of the big firms in a lot of these cases that have been brought against the second Trump administration. And it's for the reasons you're mentioning, that they're concerned as to the repercussions that could have on their other clients, future clients, on their bottom line business. I mean, it's the reason why I have had my own law practice for 30 plus years, so that I'm not beholden to anyone really, or anything other than my ethical obligations, that I can make these decisions, and I'm going to keep challenging the government. But we've had a number of large law firms who their partners in DC will help us quietly behind the scenes in a very significant way. But the law firm is managed or owned in another city where their headquarters are, that has nothing to do with Washington, DC politics. And they're too concerned about having their law firm name tagged with whether it's called anti-Trump litigation or against the government litigation. So I'm hopeful that we will see organizations like the bar associations in whether the DC Bar, the American Bar, the Federal Bar Association, and others speak up to say how inappropriate it is. I mean, essentially, it's like saying, oh, wait a second, that lawyer who's a criminal defense lawyer and got that guy off who we think's a murderer, that person should be banned from having any further clients, right? O.J. Simpson's lawyers who went on to become big celebrities and their families and everything, right? Or the Kardashians, Robert Kardashian was one of Trump's lawyers. And it would be like punishing Robert Kardashian and his family because he successfully was able to secure an acquittal for a perceived, if not known, murderer. That's exactly what Donald Trump has done, simply because he doesn't like who the clients were or the result might have been by
Right.
targeting the lawyers. That's not how our American legal system works.
Now, I would say to many people who may be thinking, oh, I shouldn't feel much sympathy for a big law firm, but you really should, because this goes to the fundamental right to choose lawyers, goes to the fundamental right of free association for their clients. And I think it goes to a bigger principle, which is in authoritarian or even fascist regimes, it's very common that they will try to pick one off after another. In the White House press corps, they've picked off the Associated Press. In the legal community, they're picking off 2 law firms plus Mark. And unless the society as a whole steps up and defends these people, there'll be no one left to defend them when their time comes. And I would say to those firms that are going along to get along, that's not a long-term strategy, because eventually you will do something to offend the Trump administration, and then you'll be in the same boat as Covington and Perkins and Mark Zaid. So it's better that you draw the line now than you let things continue. And I think this should serve as a big red flashing light for Americans that something is very, very wrong. So best of luck with all your litigation, both personal and professional, Mark. And we'll look forward to talking to you again in the near future. Take care.
Thank you, Jen. My pleasure.